I'm glad you're here. I want to talk about alternative dispute resolution methods today. Our text covers chapter 10 covers conflict resolution, and there are many methods within conflict. Matter of fact, if you plot it on a range, it'd be all the way from avoidance to war. And the text also focused some on interest-based negotiation, and Fisher and Urey's book Getting to Yes, where they reference the use of what they call BATNA, or the best alternative to a negotiated agreement. This is an excellent book, by the way, and it's available in paperback, and I'm sure it's not expensive today. I think it first came out in 1981, and the latest copyright's 91. Any conflict resolution method can have these different outcomes. They can be win-win, they can be win-lose, or they can be lose-lose. Most people are familiar with a negotiation, traditional negotiation, that ends in win-lose. As a result, many people say they hate to buy an automobile because it involves negotiation. So the automobile dealers took advantage of this and came out with fixed pricing, no negotiation, where the fixed price was below the sticker price, what they called a fair price. And a lot of people went for those deals just because they don't like having to do negotiation. Another example of complexity and outcomes is with the mediation process, and because sometimes what's called mediation it actually looks more like other processes. For example, I've had people describe court cases around divorce with children, and they called it mediation, but it really wasn't that. It was more like arbitration, where a third party made the decision for them. The most common methods, let me cover these common methods first. Negotiation certainly is the most common, and it's a mutual discussion and arrangement of the terms by two people. And they attempt to do this on their own without assistance. The other two common methods, arbitration, is a problem-solving or conflict process where two or more individuals allow a neutral, impartial person to decide for them. There's a little bit of controversy here because some companies start making arbitration a condition of employment. You go through the interview process, and just before you're hired, you're forced to sign your rights away to arbitration, and basically you're saying if there's any dispute while you're an employee, you agree to arbitration. And the problem with this is it always favors the company. And for a while we thought it was going to be ruled illegal, but the courts said it was legal. So now there's companies doing it. Mediation is the other common process, and this is a true mediation. Two or more individuals allow a neutral, impartial party to assist them, but the two individuals, they still work out the terms of agreement, and that's an important part of mediation. In Michigan, we have a dispute resolution center in every county that offers true mediation to the public, and it's in an effort to try to reduce the amount of litigation going on in the state. There's a couple of different types of mediation. Probably the most common one is called settlement, and that's where the focus is on getting an agreement, and that they do that when the parties are not apt to see each other again, like a landlord-tenant. Just get it settled. If the parties have a relationship, such as a divorce or union management, then they do what's called transformative mediation, and the relationship becomes part of what's negotiated in the settlement. There's a lot of different processes in alternative dispute resolution, and Dr. Popadak is a friend of mine who actually did her doctoral dissertation on forms of alternative dispute resolution. So I'm borrowing from her dissertation on all of these different forms. I'm familiar with some, but not all. Moderation by a chairperson. We're all familiar with this. Is somebody facilitates a meeting, and it's a low-intensity conflict, and they put out information to resolve the conflict. And then process consultation is kind of a variation of that, where they define it as a step moderation, where the third party actually provides or makes a recommendation for a process to resolve a conflict. There's problem solving. This is where an identified model or procedure is used by disputants to work out the terms of an agreement. Once again, the process is defined. There's social therapy. It's a kind of a humanistic approach to the treatment of individuals as a result of conflict. If you remember years ago, there was a baseball pitcher named John Rocker. He played for Atlanta, and he was being interviewed for Sports Illustrated, and he was talking about being in New York City when I think when Atlanta was there to play New York. And he made some derogatory comments about the diversity he experienced on a subway, and so it resulted in number one, a suspension from the team, and then he had to enter into training, sensitivity training, based on his comments, and then on completion he came back. I don't think he played very long after that anyway. There's confidential listening. That's where process where each of the disputants, they're permitted to discover the bottom line, and they do this by listening to each other. Shuttle diplomacy. This is the one that some courts use with divorce cases. Third party carries information between disputants, so the disputants never have to meet face to face. Typically, when this is done, this shuttle diplomacy is a third party operates for the courts and is familiar with settlements, and especially they're familiar with the judge that the case goes before. Neutral case evaluation. Third party experiences in a particular scope of dispute assists as a third party producing a non-binding agreement. Conciliation. Usually an intermediate step between bargaining and arbitration. Typically does not use third party. Internal tribune, a group decides the conflict. This is a little more common. Peer review is also more common. Usually within an organization there's like a panel of peers, and ethical conflicts is a good one that's used for these. Ombudsman has become more popular today. This is a person who is familiar with the system within an organization. Oftentimes, maybe they're a retired HR person, and because they're familiar with the system, they assist a person in finding the best path to resolution for whatever conflict they have. Summary jury trial is another one. This approach uses real jurors for a mock trial, and then the parties consider whatever verdict they came up with as they prepare for real negotiation. Judicial settlement is a type of mediation that assigns a judicial facilitator, very similar to shuttle diplomacy. Mini trials. This approach is a committee composed of members of an organization with an advisor, and that the advisor usually has a legal background. Also in variations, in most of these processes, they can be binding or non-binding. And if it's non-binding, let's say, for example, I used to facilitate for state of Michigan or mediate, and it was non-binding. And what that meant was we would go through the mediation process, reach an agreement, and then we would ask the parties if they want to sign. If they said yes and they signed it, it became binding, was entered into the court record. If they said no, because it was non-binding, in other words, they had a choice, if they said no, then that ended the mediation, then it went back to court and the judge made the decision. Grievance procedure example, in a lot of union contracts, I know it's true in the auto industry for General Motors, Ford, and Chrysler. And in their contracts, these steps are actually written out. And this is just typical, an example, but say if an employee has a grievance, they call for union representation. And in the first step, the union representative bargains with the first line supervisor. And if they fail to get resolution, then it goes to the next step in bargaining, where typically the union rep meets with the next level up of management. If that fails, then typically a higher level union representative meets with a senior manager. And if that fails, then it goes to binding arbitration. This is where union and management prepare their best case. It goes before an arbitrator. The arbitrator rules, and it's binding on both parties. Now, this is a good, and the reason it's good is because it guarantees that something enters the grievance procedure will be resolved, and without work stoppage. So work continues and problems are resolved, so that's why it's a good thing. In actual negotiation, there are different types of negotiation. You have position-based, which is the most common. That's where the parties they have a position. A good example of a position-based current event, it's not current today, but everybody remembers it, was the Elian Gonzalez case. It was a little boy from Cuba who washed ashore. His mother had slipped off the raft and died at sea, and he hit shore and would have been granted citizenship, but he was underage. So because he was underage, it was contested. He had a biological father in Cuba who wanted him to come back to Cuba. That was the position, and he thought the boy's best interest was served by that. The boy had an uncle who lived in Miami who wanted custody of the boy, wanted him to stay in Miami because he said his mother sacrificed her life to get him here. So they were both compelling cases. And by the way, both governments, Cuba and the United States, also had a position. Their position was international law would prevail. And in this case, it was long and involved, but in the end, international law prevailed, and the boy went back to Cuba because the biological father had rights to the custody. Interest-based negotiation looks more like problem solving than negotiating, and because what happens is all of the parties put their needs on the table, and then they work together to try to satisfy all the needs. And this is the basis for the book Getting to Yes. It's interest-based. Rights-based is what attorneys are taught in the United States. In other words, it's a legal-based negotiation based on, by law, what would a person have the right to. And then there's what's called high-low arbitration, and that's where parameters are set for high-low, and then the negotiation is done within the parameters so that the settlement cannot exceed the high or low parameters. And then last, or well, not last, but some individual approaches, but they're worth mentioning because they're very powerful. One that I like a lot was developed by Tom Pascoe, who is no longer living today, but he was a national figure in EAP. He was a close friend of mine, and he developed constructive confrontation slash assertion. So it's an approach to resolving conflict one-on-one that's highly effective. And what it does, it focuses on the dignity and respect for the individual. Then there's verbal de-escalation. This is a technique designed for conflict that hits a critical area. In other words, if there's a fear that the next step is violent, then verbal de-escalation is the approach. And then a lot of organizations use personality-based training. The most common types are the Myers-Briggs Type Indicator or the DISC, or they could use the Big Five, but usually MBTI is more common. And what do? They train employees about individual differences, and the emphasis is on dignity and respect for individuals again. So it tends to create more tolerance for individual differences. So I thought, I wanted to cover something that went beyond the book, and so maybe you found it interesting that all these different forms of ADR exist. And I'll post, actually I have a transcript. Instead of this PowerPoint, I'll post a narrative transcript. And these are the sources, the book lists, Urian Fisher, this is the Popodak source. This is available in the DAI dissertation database if you wanted to read it. Thanks.